Can Ripple beat the SEC? When will Ripple present new arguments in its defense? How much will Xrp cost after the trial ends? We will answer these questions in today's video. In the meantime, subscribe to the channel and we're getting started. Attorney Deaton achieved a significant victory on behalf of LBC token holders and the whole crypto sector in the just-finished hearing between LBRY and the SEC conducted yesterday at the Warren B. Rootman United States Courthouse in New Hampshire. Deaton, who acted as amici counsel for tech journalist Naomi Brockwell, successfully persuaded the judge that LBC secondary market transactions are not securities. In order to avoid giving clarification for LBC, the SEC sought an injunction that does not differentiate between LBRY, the company's management, and consumers. Attorney Deaton remarked that the injunction was imprecise and wide, forcing him to seek clarity for Brockwell and other LBRY users' LBC secondary market activities. The inventor of crypto law said that he referred to a paper prepared by commercial contract lawyer Louis Cohen that examined all security cases in the United States since Howard. According to Deaton, during Cohen's research of security cases in the United States, no court ever acknowledged that the underlying asset was a security. The article states that your ruling seems like you may be suggesting that LBC is security in and of itself. Deaton said to the judge in court, "If you don't intend that, Judge, then we need to explain it." After some back and forth, the judge said that he is not inclined to issue an injunction, according to Deaton. He went on to say that the judge's declaration is a huge victory since the court will not issue an injunction against LBRY users. Deaton said that he got the Securities and Exchange Commission to admit on the record that LBC secondary market transactions are not securities. Hearing on LBRY, the stakes for all crypto. Several Bitcoin fans have praised Deaton's efforts in the LBRY case, which might be employed in future crypto-related matters such as Ripple v. SEC. In a tweet today, Hogan law firm partner Jeremy Hogan praised Deaton for pressuring the SEC to state on the record that LBC as a token is not a security. The SEC acknowledged on the record that the token itself is not a security at the SEC's UV LBRY hearing. Excellent work, Mr. Deaton. Furthermore, Fox Business journalist Eleanor Terrett praised Deaton, noting that no one battles harder for the Bitcoin sector than the creator of crypto law. Takeaways. 1. In the Hellbrackham case, the SEC attorneys admitted author that secondary market transactions of LSU tokens do not constitute a security. 2. No one is more dedicated to the crypto community than Jan is more dedicated to the crypto community than. Consider how simple it would be for the SEC if it weren't for him. LBRY has the following message for SEC. Ideal for the SEC. The U.S. Securities and Exchange Commission, SEC, lawsuit against Ripple Labs is not the only battle the company is currently fighting. In fact, there's a court case that has been under trial for a longer period of time. The class action lawsuit filed by Xrp investors against Ripple Labs and CEO Brad Garlinghouse, which has been pending since November 2018. The case, which is being heard in the U.S. state of California, is led by lead plaintiff Bradley Sostek, with 3 lawsuits, Zakinoff, O'Connor, and Greenwald. Consolidated into one, the plaintiffs accuse Ripple of selling Xrp as an unregistered security and seek damages for losses suffered from the sale and alleged promises by Ripple. In addition, the plaintiffs are asking the court to also classify Xrp as a security. Attorney John E. Deaton, who is already involved with a respective amicus brief in the Ripple vs. SEC and LBRY vs. SEC cases, is now getting involved in this case as well. As prominent criminal defense attorney James Phelan writes in a series of tweets, Deaton is filing an amicus brief in Zakinoff vs. Ripple. Phelan writes that the proposed class would include Xrp holders around the world, including the 75,890 holders in the SEC case who have joined Ripple's arguments and disagree with the plaintiffs in Zakinoff, saying that Xrp is not a security. Moreover, the proposed class action is not limited to direct sales by Ripple, but extends to all sales of Xrp, including secondary sales and international sales in countries where the token has already been classified as not a security. Deaton argues in his motion that the court should not certify the class because of these conflicts and because there are only a small number of holders who claim that Xrp is an unregistered security, while vastly more token holders worldwide claim that it is not. Just added to our document library, order granting John Dayton on admission pro hacks, vice representing Xrp holders in U.S. District Court for Northern District of K in Ripple Labs into litigation. Link to order. Fred Rispoli, also an attorney from the community, commented on Deaton's move with applause, saying, "Being familiar with class actions, the class certification battle is the most important fight in these types of cases. John coming in here in this capacity is a real kick in the balls top." Plaintiff's counsel, and I don't disagree with John, but the ball kick cannot be overstated. For his part, Deaton commented on Filan's announcement on Twitter, saying, "Whether it's the SEC or a plaintiff's attorney making the absurd argument that secondary market transactions of a token are also securities simply it may have been previously offered or sold in a way that violated Section 5 of the Securities Act, I'll see you in court." The long-running legal brawl between Ripple and the U.S. Securities and Exchange Commission edges close to an end. In a tweet today, top U.S. defense lawyer James K. Filan informed his over 138 followers that as of January 19, 2023, everything is briefed in the lawsuit. This suggests that the parties, Ripple and the SEC, have made the necessary filings, including motions for summary judgment and motions to seal all materials relating to the summary judgment motion. Filan's tweet comes as part of efforts to update the Xrp community on the scheduling updates of the lawsuit. An excerpt from the attached image read, "Now we wait." Judge Annalisa Torres is currently reviewing the multiple briefs filed by the parties before making a final decision. Reacting to the tweet, Xrp community members took to the comment section to express gratitude to Filan for keeping them updated throughout the lawsuit, which has lasted for over 2 years. Attorney Jeremy Hogan, a partner at Hogan Law Firm, was among those who expressed gratitude to Filan for his efforts in keeping the crypto community updated. Xrp community attorney John Deaton also reacted to the latest scheduling updates shared by Filan. Deaton referred to Filan's latest Ripple v. Seek lawsuit tweet as the best update ever. In December 2020, the SEC dropped a bomb on the crypto industry by suing Ripple and 2 of its executives, Brad Garlinghouse and Chris Larson. The Securities and Exchange Commission claimed that Ripple and its execs sold unregistered securities in the form of Xrp. The case, which Forbes dubbed the cryptocurrency trial of the century, is expected to set a precedent for the future of the U.S. crypto market. A win for Ripple could pave the way for regulatory clarity in the United States. However, a ruling in favor of the SEC could give the regulator a powerful weapon to go after other cryptocurrency projects. In previous updates, Filan has predicted that Judge Torres would likely make a final decision on the case before the end of March 2023. Meanwhile, Ripple's CEO recently told CNBC that he expects a final resolution of the company's legal brawl with the SEC to happen in the first half of this year. Garlinghouse added that he is confident about the outcome based on Ripple's position with the law. The case is now fully briefed in front of the judge. We are optimistic that this will certainly be resolved in 2023, maybe the first half. We'll see how it plays out from here. But I feel very good about where we are relative to the law and the facts, he remarked. As reported by the Crypto Basic in Davos, Ripple CEO said that people will be stunned at the SEC's behavior when Hyman's emails come to light.